Copyright Basics. To put it simply, the purpose of copyright is to promote creativity in society. Copyright law provides an incentive to creators to encourage them to create new works. It also ensures that authors receive proper credit for their work, and thus preserves the integrity of creative works. But thanks to differing copyright laws across different countries and jurisdictions, copyright licensing and transfer, exceptions and limitations to copyright law, and related areas of law such as intellectual property, patents, and trademarks, the idea of copyright is much more complicated than it may first seem. This video will give you an overview of some copyright basics. Copyright grants a set of exclusive rights to creators. These rights include the ability to copy, distribute, perform, adapt, or otherwise use that work. This means that creators can control the use of their works by others and therefore have an incentive to create new works. Copyright applies to works that are fixed in a tangible medium and is conferred automatically at that point. Copyright does not protect facts or ideas themselves, only the tangible expression of those facts or ideas. This is a tricky but important distinction. When you think of copyright, you probably think of the following types of copyrightable works: literary and artistic works, translations, adaptations, and alterations of literary and artistic works, or arrangements of music, or collections of literary and artistic works. And depending on the country, some other copyrightable works might include applied art and industrial designs and models, or computer software. Related to copyright is the idea of intellectual property, which is the term that we use to refer to a set of legal rights that empower creators to restrict others from using their creative works. Copyright is one type of intellectual property. Other types include trademark law, which protects the public from being confused about the source of a good, service, or establishment, and patent law, which gives inventors a time-limited monopoly on their own inventions. Examples of trademarks are McDonald's Golden Arches or Coca-Cola's brand name. These trademarks help those brands protect their reputation by preventing the use of their trademarks on other goods and services. Patent law gives inventors the exclusive rights to make, have made, use, have used, offer for sale, sell, have sold, or import their inventions. How do you get copyright protection for your work? While this can vary by jurisdiction, generally copyright is automatic the moment your work is fixed in a tangible medium. For example, as soon as you turn your ideas into words on a page or record a song, you have a copyright. You can officially record your authorship by registering your copyright with your local copyright authority, and in some places this is necessary in order for you to enforce your rights or receive other advantages. But generally, you do not need to register or go through any sort of official process in order to receive copyright. If you are the original author of a work, and that work is fixed in a tangible medium, written down, recorded, saved to your computer, etc., then you now have the exclusive rights we mentioned earlier when it comes to the use or reuse of that work. Does this mean everything is under copyright? How can I use, reuse, or borrow from other creative works if only the creator has copyright? This is where certain limitations and exceptions to copyright apply. There are a number of works that are completely free from copyright, and these works are considered part of the public domain. Works enter the public domain in a few different ways, including when the copyright expires. In most countries, this happens 50 years after the death of the creator, but the term could be longer or shorter. When the work falls outside the scope of copyright protection, or when the creator dedicates the work to the public domain before the copyright term expires. There are also certain exceptions to copyright restrictions, including the concept of fair use. What constitutes fair use differs from country to country, but in many parts of the world, certain uses are explicitly allowed and exempted from copyright, such as uses for the purpose of criticism, parody, access for the visually impaired, or certain educational uses. And of course, Creative Commons licenses provide further exceptions to copyright. Depending on the type of Creative Commons license you use, you may choose to waive certain rights granted to you under copyright law, and might therefore freely allow others to use or reuse your work while still retaining your copyright. I wanted to keep this video short, and as a result, there are many, many other aspects of intellectual property and copyright that are not covered here. But you now have a good base understanding of what copyright is, how it works, and what some common exceptions to copyright might be. Use the links provided here to learn more about copyright.